Greetings, 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 greetings. It is I, your king, Clifford Jefferson, descended from the house of Godfrey, the fifth kind of Jew, son of the folk ruler of Jerusalem, and the reincarnation of King Edgar the Peaceful, also better known as King Edgar Jefferson. I have come and reincarnated in this time and era to restore your history of who you truly are as ancestors. I have, as always, by my side, faithfully, Archbishop Belmont from the House of Belmont, as well as CA, called Judah. But I cannot move forward without introducing my queen, Sister Godwin from the House of Godwin, who assisted us throughout our recent battles, going back to the Battle of Hastings. And as you know, Battle of Hastings was a great turning point in regards to reclaiming our vast estate that was left from our ancestors going back to what we call Time Immemorial. So we give honor to all those who are here today. And as always, we greet you in love. I allow my queen to say a couple of words, and then we'll proceed in procession with Archbishop, CA, and then we allow everybody to say a couple of words to everybody here on the panel, as well as those who are viewing, to say good morning to them. And then we can move on with this marvelous lesson that we have prepared for you. And I'm pretty sure it won't fail you. And with that, I digress. Queen.
Greetings, greetings, greetings. Ready for another marvelous lesson, like the king said. You know, these lessons is gonna put our households in order. Just hoping that everybody take heed and just follow along. With that, I digress.
Well said, Queen. With short words, but so much input and so much meaning to it, because, you know, we say a whole lot of stuff that don't have no meaning. And we need to shorten our verbiage in regards to getting our language across to those who need to hear it. And this is the reason why we're here today, to be able to somehow compact what it is that we're trying to say, because we have 868 years, and even that which proceeded before us, to get y'all to understand. And there's no better way to do it than the way your ancestors taught it. You know, and we have a lot of teachers, but not a lot of subscribers to those teachers. And that's the reason why we're here today. So well said, Queen. Archbishop.
Greetings, everyone, from the Kingdom of England, Empire Albion. It's I, Archbishop Belmont, from the Noble House of Belmont. And today is June 5th, 2972, Berber calendar, which is equivalent to 2022, the Gregorian calendar. And like the King and Queen has said, you know, this lesson is going to be quick, sweet, and simple, and straight to the chase. You know, I'm not going to even give that big of an introduction, because after this, you know, after this service that we're going to give, if you haven't made your way back home, then that must not mean this is the place for you. So with that being said, I digress, and I leave the rest of the introduction to C.A. Murphy from the House of Murphy, as well to our rest of our brothers and sisters from their respective houses.
Greetings, everyone. Peace and love. I trust all well at the sound of my voice. Happy to commune with the brothers and sisters once again on the King's Bench. I'm looking forward to the marvelous lessons. So I digress. I look forward to communing with you brothers and sisters. So I got my pen and paper ready. So I look forward to the lesson. I yield the floor.
Well said, well said, well said. CA, called Judah from the House of Murphy. We now open the floor for Sister Allen from the House of Allen.
Greetings, everyone. It's wonderful to be back. Wonderful to be back and see our family growing and prospering. I look forward to today's lesson as well. And I can't wait to see what's going on. I digress. Thank you.
Yes, we got a lot going on over here. Sister Walker from the House of Walker. How you doing today, Queen?
I'm super. Greetings. I like to acknowledge the King and the Queen this morning. Archbishop CA, they're doing a marvelous work, and they're working very, very hard to restore our birthright. And I'm honored to be here. And, you know, I like to welcome everybody to this marvelous lesson. I digress.
Well said, Sister Allen from the House of Allen. Pardon yourself, Sister Walker. I'm telling you, I'm bad with names, y'all. I'm bad with names, so don't hold it against me. You know, I had a lot of stuff up here, so, you know, just please forgive me. Move forward, Brother Gray from the House of Gray. Good morning, brother.
Greetings, greetings, King, Queen.
Greetings, Queen. Greetings, Queen, Countess. Greetings. Okay, all right. That's what I'm talking about. Move over, man. Move over.
This is my beautiful wife.
Greetings.
Greetings.
Welcome to have you here today. Yes. It's a joyous day today. I definitely say that today. Welcome you both again back today.
Yes.
Thank you.
Go ahead. Greg. Anything else to say?
Oh, yes. Archbishop CA and all who is tuning in, just ready to receive this lesson. I'm blessed today too to have a cousin of mine on here, Curtis Watson. So I'm happy that he's going to come in and listen and see what he thinks about it. But like I told him, just listen and you'll believe. That's for sure.
Yes.
So,
Yes.
With that,
So with that, we're gonna you digress, brother Gray from House of Gray.
No, I'm just saying I relinquished the mic.
Queen, would you like to say a couple of words?
I'm looking forward to the wonderful information that we're going to be receiving today.
Thank you so much. We appreciate your gratitude. Yes, we open the floor to Brother Watson from the House of Watson. Welcome today, brother.
Welcome. Yes, thank you so much, guys, and peace and blessings to you all. And thank you for allowing me to be in here and learn all of the wonderful things that you guys. I've already wrote down like 2 lines that I didn't even know. The 868 years, and the Archbishop said tap into frequency, and you've woken up. They sent chills through my body, and so I'm ready to gather some information and just learn everything that I can learn. And I appreciate you guys allowing me to be in and listen in.
Well said. We love you and we're glad for you to be here. Sister Pamela Jones from the House of Jones, welcome, sister.
Welcome. Very glad to be here in this oasis of peace that is so important in these times. I look forward to this session, church meeting. It's multitasks because there's so much information that I get from these group calls, and I appreciate it. I digress.
Welcome, well said. Brother Walthor from the House of Walthor, welcome back, my brother.
I got to mute yourself, Noble. There you go.
Grand Rising, everyone, family,
Welcome.
King, Queen, Brother Beaumont, C. I'm just glad to be here. Thank you for my sister, who brought me, who actually invited me in. So I just want to say thank you for the family to allow my family to come in, and I digress.
Well said. And last, if I think, that will be Brother Monday from the House of Monday. And you will be closing the doors of the temple, my brother. So welcome. Good morning. This fine, or this evening, I should say. Good to see you again today, brother.
Peace and greetings, King and Queen, and all the nobles and brothers and sisters. I'm just happy to be here today and glad I can join and see this great information. Knowledge.
Yes, sir. Well said. And I love all that was said today. Did I miss anybody? No, I don't think so. So once again, in the name of me, the King and the Queen, we greet you in love, truth, and then we greet you in the love of, in the peace of King Edgar the Peaceful, that you see on the front screen. I am the reincarnation of this deity, which we know as Jesus Christ. He was born in 943 and died in 975. And we are the existence of his descendants going back to what we call time immemorial. Today is going to be a marvelous lesson. Today I prepared for you. It's very important that you pay close attention because we always say, he who writes your books sets your timeline. He who writes your books sets your timeline. We understand that we are subject to what we call here in these territories now called the United States, a head of state. If you watch our last podcast that was put up today, you will see this demonstration articulated in that last lesson. But if you understand government, you have what they call heads of state. And heads of state is what we call a figurehead. A head of state is called a figurehead. And a figurehead is what they call a ceremonial leader. Pretty much what you've seen with the Jubilee of Queen Elizabeth II. It was just a ceremonial possession that was done in the name of the government, because they move by what they call royal prerogatives. Royal prerogatives are powers taken from the legislative branch and executed by the executive branch, pretty much what they do over in the United States with the head of state, known as the president. He gets certain powers from the legislative branch and exercise them on the executive branch, but they have to be in line with the legislation because they become contrary to that, which brings forth the judiciary. And why is this so? Because they're not the original crown. I repeat, they are not the original crown. The crown, THECROWN. So once again, it's going to be a marvelous lesson. I mean, for all those who are viewing this outside of the English Temple Church, those who are silent, I suggest that you definitely do a historical, legal reference to support your narratives. Because common law, under the judicial review of those who judicially review so-called law, and we know there's only one type of law, and that's called common law for us as English heirs and successors. And we know that's not law decided by judges, whether they're inferior or not. Our law is not based off judges. That's their common law. Our common law, according to their common law, Smith versus Alabama says that in the sense of common law, on the national cumulary law sense, there's only one, which is called the common law of England, which was adopted by the several states and used as their political local law or public local law, and subject to such alterations as provided by the statute. So this is not interpretations of judges. This is what the legislation have enacted and has been coded by way of the statute, that the judges, all executive officers, all departments, inferior, superior, have to follow. That makes sense to everybody?
Yes.
Okay. Let's get down to business, y'all. Now, Archbishop said, I need to make this, before I go on, Archbishop, you want to say a couple of words?
No, you're doing perfect, King. This lesson, okay. So I'm not gonna pretty much have to say much. It's self-explanatory.
Okay, all right. Let me share my screen. Now, just everybody pray that I don't have no problem today with my internet. Let's hope that's the case.
All right, the share screen set up.
I got you. Just give me 1 second. Share.
Share screen.
Did you see the crown?
Oh, the crown?
Yeah. It's supposed to pop up. Let me go back. Give me a second, y'all. Let me get this right. Oh, I know I did it wrong. Share. Right in front of my face. Okay, can everybody see that? Yeah, that's what I want.
Yep.
First, let's go here, the crown. That's nuts. Please don't do this to me. I knew it. Oh, here we go. All right. Can everybody see that, right?
Yes.
Yep.
Okay. Sister Allen, do you mind reading? I'm going to ask for everybody to participate today because participation is activation.
The crown is the state in all its aspects within the jurisprudence of the Commonwealth realms and their subdivisions, such as the crown dependencies, overseas territories, provinces, or states. Legally ill-defined, the term has different meanings depending on context. It is used to designate the monarch in either a personal capacity as head of the Commonwealth or as the king or queen of their realms. It can also refer to the rule of law. However, in common parlance, the crown refers to the functions of government and civil service.
Okay, stop right there. So the crown denotes to the dependencies, overseas territories, parishes, and states. That's under the Commonwealth, in which Queen Elizabeth is head over. She's head over all the Commonwealth. Under the sovereign states, all the presidents are head of the sovereign states. Why? Because in the United States, all the sovereign states gave up their sovereign to join the United States. So now they're under one executive officer, also called the head of state, which is called the president. All right, and it says that the crown is the function of government and the civil service. All right, continue.
The corporation soul. The crown is the legal embodiment of executive, legislative, and judicial governance in the monarchy of each Commonwealth realm. These monarchies are united by the personal union of their monarch, but they are independent states. The concept of the crown developed first in England as a separation of a literal crown and property of the kingdom. I'm sorry, did I get that? I'm sorry.
Can we back up a little bit? I apologize.
Okay.
All right, start back from the concept of the crown.
The concept of the crown developed first in England as a separation of the literal crown and property of the kingdom from the person and personal property of the monarch. It spread through English and later British colonization and is now rooted in the legal lexicon of the United Kingdom. It's
Stop right there. Stop right there. So it said the concept of the crown developed first in England as a separation of the literal crown. This is called corporation soul. A corporation soul is a legal entity in a natural person at one time, fulfilling an office. And the office is head of the executive and legislative and judicial branch, because the land is no longer headed by a head of state. The land is headed by a monarch who has supreme power over the government because it represents the crown. If you got a crown, you got to have crown land, and the crown land is the lodio. Is a lodio. That means he owns it all, him and his descendants, because it's the monarch who grants a grant, and it's the grantee who receives the grant. Then it said that the crown is spread through English and later British colonization and is now rooted in the legal lexicon of the United Kingdom. Let me go down a little further. United Kingdom and the crown dependencies and the 14 other independent realms. Okay, and this is what the Queen Elizabeth rules over. Now, what's important that we need to make distinction between English and British. Do everybody hear me?
Mhm.
There must be a distinction between the English and the British, because the English, they didn't say English colonization, it said British colonization. Didn't they say that?
Mhm.
Yes.
And we know if they say colonization, that means that you are a foreigner. If you colonize something, then you're not originally from there.
Mhm.
And they're talking about, or the subject matter is the crown. Now we're here in the United States, and we incorporated through a certificate of incorporation, because the certificate of incorporation, let me just go to the definition real quick so everybody can know for themselves. A certificate of incorporation. A certificate of incorporation is a legal document license relating to the formation of a company or corporation. It is a license to form a corporation issued by the state government, or in some jurisdictions by non-governmental entities, corporations. Its precise meaning depends upon the legal system in which it is used. Commonwealth system, remember Commonwealths are under what we call the British Parliament, under the monarch, and heads of states under what we call sovereign states are headed by the president. So now we're not speaking in this jurisdiction under what we call the president of the sovereign state. Now we're defining it under the Commonwealth, which is headed by what we call Queen Elizabeth II, who descended down from other monarchs. So it says the Commonwealth system in the United States, a certificate of incorporation is usually used as an alternative description of incorporation articles of incorporation. So now when the United States became the United States, they derived their authority from the original corporation or charter called the Articles of Incorporation. Does that make sense to everybody?
Follow.
Any questions? Okay, I'm gonna assume you know. So if I ask you all this later, I expect that somebody, I don't want nobody to say, I didn't get that. Because you're not here, you're not a baby anymore. If you're sitting amongst this class right now, you're not a baby anymore. When you was a child, I thought like a child. But when I became an adult, I put away childish ways. Because I'm gonna hold you accountable for this information, because we're only shown as our weakest link. And as we said, Brother Monday closed the door. He closed the door of this church. So anybody contrary to this understanding who's sitting up in this church right now and don't understand this information, because I just asked the question, did everybody understand? And did nobody say anything? We are going to hold you accountable. You see how serious this is, everybody? I need everybody to say yes.
Yeah.
Yeah.
Yes.
Yes.
Okay. It says in the United States, a certificate of incorporation is usually an alternative description of a corporation of articles of incorporation. It says the certificate of incorporation or articles of incorporation form a major constituent part of the constitutional document of the incorporation, of the corporation. Point and simple. Let's just go here for a reference, and then we can go back to the crown.
And point of interest, remember, articles of incorporation is another way of saying a charter for those who
Yes,
don't
charter. Now you see here, Article of Association, they give you for the articles adopted by the First Continental Congress in 1774. That's a contract.
Mhm.
That's an agreement. That's an oath. And there's nothing but people getting together, forming a community based off members, and then coming together and incorporating If colonists can do it, then we can do it as natural people, as nationals. Because as we said, the crown was first established in England under the authority of the English people, and then it was brought over by the British by way of colonization. So if British colonized this territory prior to be called in America in the colonies and British under British minority, it had to be England. Does that make sense to everybody?
Yes.
Yeah.
Okay, back to the crown. It's gonna blow your mind. Now I said it is not to be confused with any physical crown, such as those of the British regalia. Now that's what you see dealing with the ceremonial processes of those heads of states every time one is inaugurated. That's what you see, either British regalia of the Commonwealth or regalia from what you call the United States, dealing with their heads of states. All right, let's move forward. Type it back, 1 second, y'all. Type it. Okay. The term is also found in various expressions such as crown land, which some countries refer to as public land or state land, as well as some offices such as Minister of the Crown, Crown Attorney, and Crown Prosecutor. So now you're dealing with the crown and crown land. So if you got the crown must involve crown land, because it said the crown represents what? Executive, legislative, and judicial authority. Didn't it say that under corporation soul?
Sure did.
It had all the authority based off all the overseas dependencies, territories, parishes, and states. Because you just said down here, public land, states and land, or crown land. That makes sense to everybody. Let's take it, that brings us back to here. Crown land. All right, go back and go ahead and continue to read, Sister Walker.
Sister Allen.
Sister Allen.
Crown land, sometimes spelled crown land, also known as royal domain, is a territorial area belonging to the monarch who personifies the crown. It is the equivalent of an entailed estate and passes with the monarchy, being inseparable from it. Today, in Commonwealth realms such as Canada and Australia, crown land is considered public land and is apart from the monarchy's private estate.
Stop right there. Now that's funny, because Canada, as they just mentioned, is under the authority of the head of state of the Commonwealth of Queen Elizabeth II. Actually, that's her home. But it just said here, today in Commonwealth realm, such as Canada specifically, crown land is considered public land and is apart from the minor private estate. So it's all under the authority of crown land. And crown land is under the crown. And the crown is the executive, legislative, and judicial branch, right? Under corporation soul, who is the head of the crown on the crown land, which is, as it just said, is the equivalent to an entail estate. Let's hear entail. We know what a state is. A state is something left for an heir, which is usually involved in what we call property, assets. We know it ain't talking about money, because money is funny today. That's paper money, that ain't money. All right, so usually when you're dealing with, because if you ain't have land, where would you spend it at? You can't build banks on seas. They don't have banks on boats. So it just said crown land under the crown, under the monarch, as a corporation so has the legislative, executive, and judicial authority. Why? Because he's not just a figurehead. He's not just a head of state that's going through a ceremonial process by way of you assuming to be sitting on the throne, but you can't be sitting on the throne. Why? Because today we're going to show you what the Supreme Court say about the crown. All right. Now it says that the Canada, crown land, and considered public land, and departed from the minor private estate. Now, what is entail? Read, Sister Allen.
Detail. In English common law, fee-tail or entail is a form of trust established by deed or settlement, which restricts the sale or inheritance of an estate in real property and prevents the property from being sold, devised by will, or otherwise alienated by the tenant in possession, and instead causes it to pass automatically by operation of law to an heir determined by the settlement deed.
That's cool, right there. Keep going for a second. Keep going go a little further.
The term fee-tail is from medieval Latin, foedum taliatum.
Archbishop, help out, Archbishop.
Theodum taliatum.
Thank you. Theodum taliatum, which means cut short fee, and is in contrast to fee simple, where no such restriction exists and where the possessor has an absolute title, although subject to the allodial title of the monarch and the property which he can bequeath or otherwise dispose of as he wishes. Equivalent legal concepts exist or formerly existed in many other European countries and elsewhere.
That's fine. Okay, so there's a difference between fee and tail or entail. Entail is an estate left for heirs and successors, not just a successor. You have to be an heir. In fee and simple, it can go to a successor, which has been the case from 1787, which if you read the prior podcast, we've shown you, but you don't have the eyes to see yet because we have to slow the frequency down. So it said, and property which can be bequeathed or otherwise disposed of as he wishes, only the king. Why? Because it's just said it's allodial. It's allodial, it belongs to the king, and he gives the entail to his heirs and successors. If it's not heirs and successors, then it's by way of what we call colonization. And somebody claiming to be a successor and opposing to be an heir, but they're not an heir. All right, because why? Fee and simple. Now, what is fee and simple? Let's go here. Common recovery. Sister Jones, do you mind reading?
Sure. A common recovery was a legal proceeding in England. I can't see that.
Oh, I'm sorry. Give me 1 second.
Okay.
You need to make it bigger?
Yes. Oh, okay. To the other way at night, because I'm getting, okay. Maybe a little less and to my left. Okay.
Let me just close this down.
Okay.
What about now?
Okay, that's better. I just got to go down.
All right, let me go back up this down.
Okay, all right, that's better. Okay, a common recovery was a legal proceeding in England that enabled laws to convert an entailed estate.
Lawyers.
That enabled lawyers to convert an entailed estate, a form of land ownership also called fee-tail, into absolute ownership, or fee simple. This was accomplished through the use of a series of collusive legal procedures, some parts of which were fictional and others unenforceable and therefore null. It was devised and perfected by lawyers in the second half of the 15th century. A 1472 case known as Talterum's case increased its popularity. Entails were originally designed to keep ownership of land within a family. Thanks to the effects of the statute de donis conditionalibus.
Well said. Well said.
The intent of the entail could not be broken. This meant that land in fee tail could not simply be sold, transferred, or mortgaged as whatever the current owner did with it. Ownership would automatically pass on their death to those specified by the entail.
Stop right there. Stop right there. Okay. Now the difference between entail and fee and simple was that, as they said, was a legal fiction. We know what legal fiction means, abstract, colorful, de jure form of doing things. Now, when you have, or when you buy a house, it said mortgage. Majority of us have what? Mortgages, am I right?
Yes.
When you have a property, which is supposed to be entail, it's automatically supposed to transfer to you as an heir by way of you being English by operation of law, just like a birthright is supposed to do. Because when you got a trust left for you, usually inheriting the estate, it usually involves property. And this was protected, the donus conditionalibus. This was done by Edward I. Edward I was the son of Isabella of Provence and Henry II, son of Godfrey V, Count of Anjou, going back to the Plantagenet and Angevin dynasty. But when they stole our state, they did it by way of a process, as we just stated, called common recovery, which was a legal fiction. And this meant that land and fee tail, i.e. entail, could not simply be sold, but transfer or mortgage. So now they got you paying taxes on property. Why? Because you don't have the right of ownership, you property. This is the position Dred Scott found himself in. Property cannot own property. If you are an American citizen, then you're not a national, because it's either you're a colonist, now called an American, or you're an English heir and successor, which has always been here, as we're going to see as established by the case law we're going to be reviewing in a minute. But as we see, that the donus conditionalibus was a legislature passed by Parliament. In Parliament, this is part of what we call the Westminster system. The Westminster system is based off parliamentary sovereignty or parliamentary legislative law or supreme legislative law. And parliamentary government was established by what we call a model parliament, established by Edward I, son of Eleanor of Provence and Henry II, son of Godfrey V, Count of Anjou, where my surname descended down from. Before that, you had the original parliament, which was the Parliament of England, established in 1215. These were your peers. These were your ancestors that when somebody hurt you or did something contrary to the law of the land, i.e. the common law, these are the ones you went to. Why? Because you were a Lord in their eyes. Didn't Jesus say, for you are all lords, children of the Most High. So we are all peers. We are all, what they say, a trial by jury amongst your own peers. You don't get that because there are no English people here. That's why we have to establish ours, so be able to take our property and ownership back by way of entail that was left back by way of what we call operation of the law. But in order for you to know the law, you must go back to where the law started. Because this is where their common law comes from, English law. All right, let's go here. So we know background of entail estates was a process done based off creating based off legal fiction. This is what you call a straw man. The Negro, the Black, the color. All these were given what they call a straw man certificate or a settlement certificate. The settlement certificate is an instrument for settling. So they all automatically classify you as a colonist because they granted you. A grant is given by somebody. It's not a birthright. That's why we say there's a difference between a live birth and a right of birth. What Dred Scott got was a live birth. Why? Because he was subject to that of the monarch, King James and his successors. They were not heirs to the English throne, but but they were sitting on the English throne. Why? Because all the English people were being enslaved and put in the mix with the same boat, in the same boat with all the colonists and what we call on the plantation. All the colonists and those on the plantation were all indentured servants known under the term what they call citizen. A citizen is given citizenship by what we call a letter patent. A letter patent is a grant given by a grantor, and the grants given by the grantor was a head of state under a commonwealth, which Elizabeth II sits on now, going all the way back to King James, the 6th King of England, Scotland, and presumed to be the 1st King of England, under a defunct parliament called the Commonwealth. And as we said, that they're not the crown. They're just a figurehead. They're just a ceremonial leader to fit or sit in the position of the crown until the true monarch comes in and claim his crown land by way of incorporating back into the original contracting party, which is called a constituent corporation. I'm gonna say it again, constituent corporation. If all those who want to know the statute, that statute is New Jersey Revised Statute 16:1-43.7, 8, and 9. So this is nothing fabricated. This is common law interpreted through the statutes as we stated under Smith versus Alabama, which was adopted in all the several states prior to them being called colonies. They stopped being called colonies when they amended the Constitution September 20th, 1777. Okay, let's move forward. Everybody follow? Any questions?
Goes to show.
Well, y'all know.
Like it says, goes to show you to utilize common recovery to remove you from what we say an entail estate. And so only way for you to be able to receive your entail estate back is you got to utilize the same thing, but it had to be done under the monarch underneath the lodial title.
Yes, well said, Archbishop. Okay, real quick. This is recourse. We're gonna brush right through this. History of vital statistics, up here in the top corner. Government records. Read this, Sister Walker. No, who was reading?
I was.
Sister Jones, continue reading.
Yes. Okay. Prior to the creation of the General Register Office, GRO, in 1837, there was no national system of civil registration in England and Wales. Baptisms, marriages, and burials were recorded in parish registers maintained by Church of England Anglican clergy. However, with the great increase in nonconformity and the gradual relaxation of the laws against Catholics and other dissenters from the late 17th century, more and more baptisms, marriages, and burials were going unrecorded in the registers of the Anglican Church.
Stop right there. Now we see prior to the General Registration Office and the Births and Death Registration Act of 1837 and 1874, which you will see explained in our last podcast, it was all registered under the Church of England. And the Church of England goes back to the English Reformation of the English Church of England, which you are all on this bench are part of, and in regards to you coming to Sunday school. And then you follow the latter formality that's instructed by Archbishop when you get further situated in the temple in regards to your membership, or what we call citizens. So it said prior to the creation of General Registers of the Birth Registration Act of 1837, we were registered, all children born was registered under the Church of England, not as citizens, but as property. Because if that was the case, Dred Scott would have not been in the case he was in. Would y'all all agree?
Yes.
That
Agreed,
means
agreed.
he was the nonconformist.
Mm.
He didn't know who he was, but he know he didn't want to be registered with that Church of England, so they penalized him. This is the reason why the contract we have, I don't care what it is, a driving license, a registration card, all those are contracting that denotes to citizenship. If you carry it in your pocket and you could pull over and it's a valid one, then you are a citizen. I don't care what you say. I can see if you had it in your pocket and then when they stopped you and said that that contract has been null and void anymore because it's invalid.
Mhm.
But I'm just showing you that that contract is null and void, and this is who I am now. Now, if you hold me to this, then that be what we call religious discrimination. That's a violation of my civil rights because you are a member, i.e. citizen of the English Church of England, because according to diversity of jurisdiction, that still deals with citizenship, which we're going to go through in a second. All right, that's all we need to hear out of here. Let's go here.
In point of interest, the most important part of that was speaking about nonconformity and dissenters. When you come into the church, you just can't do what you want to do. You have to conform to the church, not the church conforming to you. And this is what happened to a lot of the denizens. They didn't want to continue to go according to what was already prescribed for them. So they wanted to do something different. And as you see what they did something different, they were not recorded amongst the living. And that's what happened to many of our brothers and sisters after they came out of the Church of England by being pushed into the Episcopal churches or the AME churches that removed your status as being connected going back to the Kingdom of England and placed you underneath the property of the states because all of the churches at this point became state churches and not free from the so-called state.
Well said, Archbishop. Well said, Archbishop. Okay, Sister Jones, you can continue.
Recorder of deeds or deeds registry is a government office tasked with maintaining public records and documents, especially records relating to real estate ownership, that provides persons other than the owner of a property with real rights over that property.
Read that again.
Recorder of deeds or deeds registry is a government office tasked with maintaining public records and documents, especially records relating to real estate ownership, that provides persons other than the owner of a property with real rights over that property.
Now, everybody, I want y'all to stop for a second and question yourselves. If your mortgage, which is established by a deed, is filed with the county register and it gives property ownership to somebody other than the owner, then the question you need to ask yourself, are you the owner? And I'm pretty sure all y'all would say no. Now, is that mental slavery or not?
Yeah, absolutely.
Yeah.
Yes, it is.
Yes, it is.
Now look who they got to record it to make it so bad. Frederick Douglass.
So he was the first one.
Point of interest.
Go ahead, C.A.
What they've done is they've got you to be complicit in a commercial scheme. With a mindset, you are in collusion with the state into bartering, trading, and selling of the property and receive a certificate in lieu of title. So it is your complicit commercial activity that is perpetuating this system. And unbeknownst to yourself, if you're not a member of the King's Bench, you would not be relative to this particular set of knowledge. So with the commercial mind state, what they have our people doing is enjoying the fruits and the labors of purchasing a property and then selling and then reaping the fiat or financial gain in the form of their currency as a trading value in exchange for the land. So you then start to be agreeable, or you start to enjoy the fruits of that system, but you fail to realize the fruit of that system is a poison fruit. discriminating against your entail rights of the land, so that it doesn't pass to your heirs, but passes by operation law to a system going back to the state. I yield the floor.
Well said, CA. We have a new comer. Welcome, Sister Harris from the House of Harris.
Are you muted, Sister Harris?
Take your time. Yeah, everybody want to make sure they be able to hear. We don't want to miss nothing up here. How it sound so far, y'all? Sound good?
Good sound, King.
Absolutely wonderful.
Indeed.
Sounds amazing. Amazing.
Absolutely.
It's gonna get better. Y'all ain't heard nothing.
Point of interest,
Sister
like
Harris, can we hear you?
Greetings, can you hear me?
Oh, yeah.
Greetings. I allow the Queen to say a couple of words. You can greet the Sister Harris.
Greetings, Sister Harris.
Greetings. I was invited through Sister Allen and the Archbishop Beaumont sent me the invite. So I'm grateful to be on the call. I've been studying for a few weeks, and Lady Allen been helping me. But thank you.
Welcome.
Glad you're amongst us today.
Welcome.
Welcome.
Sis.
Thank you.
Okay, let's get started. Let's get busy. All right, let's see, where was I? Okay, well, I'm gonna allow everybody to participate today because this is what we do. We're gonna have Sister Walker now. Let's see, where was I? Where do I want to go?
Now, point of interest.
Go ahead, Archbishop.
What they just read regarding the recorder of deeds and then saying registering something that actually wasn't truly yours. We got to put into the understanding that we're dealing with, like the King said, mental slavery, which is still considered mental illness. So when you're running around here and saying you got money, which you know there's no such thing as money, that's mental illness. When you say you own property when you know it's not yours, mental illness. So whenever you continue to keep doing anything that's outside what the law already instilled, which you know is not true, mental illness. And like we said, only the true tacticians, i.e. the true healers, which is the church, can come back and bring you out of this.
Sir, it was the church who did it.
The
I
fake
wish
church.
you stated, the Church in England is your downfall. The 1580 Religion Act says that it was a violation of the Treasons Act to deny English subjects their allegiance to the Church of England. Hold on. How can that be? When we were, all our assets was liquidated in the 15th century by Henry VIII. But you telling me we have to pay our allegiance there? So that was the enslavement that we are being registered to without vital statistics or the Department of Biostatistics or the one who created the birth certificate even being aware of it. Because when they stopped doing it in the churches, the city, the counties took over it. And then they created one for the states. And you're not under the state because you still live in ecclesiastical jurisdictions under the Pope. You're subject to Rome because why? You don't have a nationality. When you were born inside the church. Even though the church is unseen, you're still born in the church because the origin of the birth certificate and the order of vital statistics before they amended it to what they call now the vital statistics and Department of State, it was called the Church of England. And you still make property. How do we know that? Let's read this.
And in this
Sister
case,
Walker, you can read it.
England, for those who are just now listening to this, the Roman Catholic Church of England.
Roman Catholic Church, Anglican, Protestant, Lutheran, Methodist, I don't care what branch you come from, you are a dissenter from the Roman Catholic Church. You're still Roman Catholic. You can't separate, you can't throw your allegiance off. You are who your forefathers were without doubt or contradiction. So each one of y'all have a choice to make. Either you're going to be English or you're going to be a foreigner. Because they got regular. Right now, you registered with their system. Their system is their government. Their government is run by their officers. Their officers run by their procedures. Their procedures are governed by their statutes. Their statutes governed by their legislation, and their legislation is governed by the Constitution, which govern the officer, which according to the Constitution, keeps them in what we call encumbrances and duties that they got to follow. But it don't give any rights. It only protect rights. And the rights that they protect is not that which is in that Constitution. Because you go by amended constitutions in these days and times. So when you go back to the original Constitution of each state constitution, you don't hear them talking about states. They're talking about colonies. Now you got to make a choice. Are you a colonist or are you the one that they ain't talking about in that contract? Because if there's a colonist, they are assuming the administrators that was given by the grantor for the grantee, which is the beneficiary, which ain't came up yet. Who is the beneficiary? Because there are entail estates sitting here dealing with crown land under the crown. And you can't get it. Why? Because ain't no king. You're going to read it directly from case law. All right, Sister Walker, go ahead and read.
In the law of the United States, diversity jurisdiction is a form of subject matter jurisdiction that gives U.S. federal courts the power to hear lawsuits that do not involve a federal question. Diversity jurisdiction requires two conditions to be met. First, there must be diversity of citizenship between a lawsuit's parties, meaning the plaintiffs must be citizens of different U.S. states than the defendants. And second, the lawsuit's amount in controversy must be more than $75,000. If a lawsuit does not meet these conditions, U.S. federal courts will normally lack the power to hear it unless it involves a federal question, and the lawsuit would need to be heard in state court instead. The United States Constitution in Article 3, Section 2, grants Congress the power to permit federal courts to hear diversity cases through legislation authorizing such jurisdiction. The provision was included because the framers of the Constitution were concerned that when a case is filed in one state court and involves parties from that state and another state, the state court might be biased towards the party from that state. Congress first exercised that power and granted federal trial circuit courts diversity jurisdiction in the Judicatory Act of 1789. Diversity jurisdiction is currently codified at 28 USC 1332. And
right there. That's fine. That's fine right there. Okay, so under the United States Code, the United States gives the district court to hear matters concerning diversity of jurisdiction in regards to citizens of different states. Now, not only you got the United States, but you got the states that make up the United States, which is called the sovereign states. But each state gave up some of their sovereignty to join the Union in 1789. In 1789, they became the United States, and then in 1790, they created what they call the Residency Act. They also have what they call the Naturalization Act of 1790. So when they became residents, they naturalized all their citizens in what they call districts. A district is a municipality. So all the local laws that you are subject to in the state, which is created by counties, which is created by municipalities, is where you do most of your local business, right? Now, didn't it just say under Smith versus Alabama that under the common law of England, there's only one common law that the several states has adopted as their local laws, as their public laws, and subject to some alterations as established by the statute. But when you go into the state or a county or a municipal court, they ain't got no common law of England because they don't know what the common law of England is. They don't have to know what the common law of England is. Why? Because they assume ain't no English subjects there. And that's why you come in. Why? Because it becomes now a diversity of jurisdiction. You assume me to be a citizen, a member, a partner, limited liability partnership as a result of the instruments that denote to me being a citizen, member, partner, which is a driver license, a SIMS card, a YMCA card, all the amenities and benefits that they give you as a state would automatically qualify you for the county and the city privileges. Does that make sense to everybody?
Yep.
But you become a member and you gotta follow membership rules. You don't follow membership rules, what they can do? They penalize you. They can right now, if you ain't part of the society, they ain't honor no IDs. We don't accept that. That's the script. They can't break script. So this is why there's diversity of jurisdiction in regards to who you are, in regards to your civil rights as an English national, because of the diversity of jurisdiction. You can't talk about subject matter until you got jurisdiction, and jurisdiction means law declared. Juris means law, and dictation means what law you're declaring to mean that I'm subject to you. Nothing you give me could denote to who I am, because it don't denote to a live birth, something you put on there. Where does it denote to a right of birth and anything that you gave me? It don't denote to a nationality. Everybody got a right to nationality when they're born, right? You got me as black. Dred Scott, you see where Dred Scott got it? Got when he declared him to be an American citizen under the identity of black, or whatever you choose to call yourself in these day and times. It don't matter, because you are a foreigner to the laws here under the common law of England. So either you're a natural born subject being born on the soil still don't make you a citizen. You could be an immigrant here on the soil, still don't make you a citizen. You could be a foreigner here on the soil, don't make you a citizen in lieu of what we call just sanguineous, right of blood. This is where your protection come in by the right of blood, by your surname. That's called patrilineal descent. That was passed down to your mother and father. You got to somehow, whether it was through amalgamation, which still connects you to it. Why? Because you can prove that that name, which they're using to denote to either a German translation, a Spanish translation, a Scottish translation, a Dutch translation, all those comes with involvement of a foreigner. That's the reason why when you get to common law of England in regards to agnatic succession, when it was established under what we call agnatic succession, that everybody else who would be born after Henry II, according to John, he said that agnatic succession will be based off the Anjou's line. And Anjou is Godfrey. That's where my name Jefferson comes from. And the word son is the prefix where it means come down from. So it's through my descent family in regards to agnatic succession, which was broken as a result of those bad blood, which was done by the Roman Catholic Church, whether it's come from the Spanish, whether it comes from the Franks, Roman Catholic, Dutch, Norman, because all those are successors of predecessor wars that were involving the Roman Catholic Church and the Plantagenet crown under what we call Anjou. And Anjou inhabited France. France and England come under one rulership by way of the marriage, what we call Matilda and King Edward the Peaceful. Godfrey the Fifth Count of Anjou. When they married each other, it's called the anarchy. When England and France became one, all this encompasses the whole territory. It was an empire called Albion. We call it Jerusalem in this day and time, because King Godfrey, the Fifth Count of Anjou, where I descended down from, his father was called Folk, who went on to rule Jerusalem. Just get into what we call the Crusade Wars. They give it to you all over TV, but you have no clue who it is if you don't know the history, because history and you are one. So you have to trace yourself back through the history, and then it starts to come alive. What you're doing now is what you call re-encoding your DNA. You're starting to wake up now. And no matter where you come in the picture, you're still in my father's house. Why? Because he said, according to their scripture, in my father's house, there are many mansions. Didn't he say that? So no matter what house you come to, if you connect back to this house, you're safe.
Absolutely.
Why? How do we know that? Based off your understanding. Because when you understand something, you follow what you understand. That's by way of information. Information to be information. Inform, your true form. You was out of form until you came upon this information. Now, when you come upon this form, you come across what you call a fork in the road. Now, old form is telling you, hold on. Hey, buddy, what you doing? This is not you. What you doing? You're going the wrong way. No, you stopped going the way in which you didn't have any direction. You're going back for instructions. You're going back for instructions. The instructions just are coming through me as in a vessel. We are all vessels for those instructions that come from my ancestors. Why? Because they have always been alive through the blood, which is what we call agnetic succession, or what we call autobiological memory, or what we call daydreaming. Right now, all y'all sitting up on this panel is daydreaming right now. You're dreaming about a time when you were back with your ancestors and you calling on the assistance of your ancestors. Remember what the slave said in the movie, what was it, Amistad? When he went to Benjamin Franklin and he said, what did you say to them judges? He said, I told them what you said. Meaning understanding the law, the common law. They weren't enslaved, they were indentured slaves, but all those inhabitants of that territory were retaught, just like we were taught here.
Oh, he said, I use your words.
He used your words. If you look at the languages of everybody's language, it is English with a slang, with a twist. I don't care what country you go to, everybody speaks English, but it has a twist to it. Because of the foreigner amalgamating with us and acting as he was the superior or the original one of that land. This is not bias, just the facts. And we're gonna show the facts by case law, by those, because we can talk this on the street all day, we can be in a church all day, we can be in a park all day, holding up signs. But this church is not just a church, this is a court of law. It's called the King's Bench. The English Third Temple Church, and they're represented by the King's Bench because it's where we uphold our laws. Under the corporation code, we have the legislative, executive, and judicial authority to deal with our protection for our members. And I'm about to prove it to you in a second. I know I'm going on and I'm babbling, but there's a reason for that, because y'all need to realize how important it is by what they call constant reiteration. You keep talking to yourself. I am this, I am this, I am this. And I'm about to show you this is what you are. Let's move forward. This is a modern day statute. Oh, I missed something. What was that? Diversity of jurisdiction. Where'd that go? Oh, okay, here we go. All right, let's go here. Continue to read.
Diversity of parties. Mostly, in order for diversity jurisdiction to apply, complete diversity is required, where none of the plaintiffs can be from the same state as any of the defendants.
Vice versa. If you're a respondent, you will be a defendant. If you're a defendant, you'll be a respondent. But in any party that you are, whether you're a respondent, appellate, defendant, plaintiff, complete diversity must exist between both parties of the state. And it just don't mean state. Why? It's about to show you. Go ahead and read.
A corporation is treated as a citizen of the state in which it is incorporated, and the state in which its principal place of business is located.
Read that again.
A corporation is treated as a citizen of the state in which it is incorporated, and the state in which its principal place of business is located.
Stop. Now, how are they using the word citizen for corporation? I mean, how is that even coming up? Are you calling me a corporation? Because I am living in the state, but I'm a citizen, but I ain't a corporation, or am I? Because based off the diversity of jurisdiction, as they define, a corporation is also a citizen. And everything you got to prove who you are comes from what? A corporation. And it comes from your national government or your people for your protection. It came from them. So that means you are a citizen. They don't care what you say. Why? Because they say you got ID to prove you are. And you go put that up. If you don't got that ID, you better have something that denotes to who you are in regards to it being recognized by way of you, what we call a settlement certificate. Something that proves you have the right to be here. Right? Your affiliation, it just said, if a church is a non-business or religious society, which is also what? We are what we call a corporation sole. Because that's where our citizenry come from. We are citizens of the English Third Temple Church. We are members of this church. We're not doing business because church and state is separated. We're not part of your state. If we were part of your state, then there could be no diversity of jurisdiction. Now read on, continue.
A partnership or limited liability company is considered to have the citizenship of all of its constituent parties members.
Okay, all right. So as you can see, partners and limited liability companies are considered to have the citizenship just as the same as any identity or person living in the territory want to call themselves. You're a citizen, you're a corporation, no matter what. Makes sense, everybody?
Follow.
Yes.
Okay. Sister Walk, I think Sister Allen was reading. Wasn't you, Sister Allen?
That was Sister Jones.
Sister Jones, I think Sister Jones had a go. I think Sister Allen was reading. Am I right or am I mistaken?
It was actually Sister Walker.
It was Sister Walker, yes, Sister Walker.
Okay.
Sister Walker, you can continue. All right, now let's get into the meat of this. All right, I'm gonna read this last part and then we can really get busy.
Now pay attention to what he just said regarding corporations having the same citizenship as so-called people, which how can that be?
Well said, Archbishop. Sister Walker.
Article 6. All debts and engagements entered into before the adoption of this Constitution shall be as valid against the United States under this Constitution as under the Confederation. This Constitution and the laws of the United States, which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States shall be the supreme law of the land, and the judges in every state shall be bound thereby. Anything in the Constitution or laws of any state up to the contrary, notwithstanding, the senators and the representatives before mentioned and the members of the several states legislatures and all executive and judicial officers, both of the United States and of the several states, shall be bound by oath or affirmation to support this Constitution, but no religious test shall ever be required as a qualification to any office or public trust under the United States.
Now stop. Something wrong with that picture. Something very wrong with that picture because you said that, one, you said no religious test should be ever required for qualifications in offices of a public trust under the United States. When you go back to the Settlement Act of 1940 and the Naturalization Act, or the Settlement Act, Plantation Act of 1940, which is the Naturalization Act of 1940 under William III, it clearly states that no Protestant can inherit any property or sit any trust if you are not born of an English parent. It clearly states that. Not only that, just like it said here under the amended Constitution of 1789, if you go back to July 2nd, 1777 Constitution, under the Article 22, it clearly states that the common law should remain as the common law of England and the New Jersey, and subject to such alteration as required by such statute. But it says in Article 19 that the, what is it? if I'm not mistaken, Article 19, it says that the Protestants, it speaks specifically about the Protestant church having the right and liberties and are able to hold trust. So now that's contrary to what William III said when they allowed you to come over here as a colonist. You wasn't supposed to hold any trust. Why? Because the only person going to hold a trust was the heirs and successors of the trust. Why? Because you have to be a beneficiary. So they went contrary to everything that was established. How we know that? We're going to hear from these judges. And with that, let's get busy. First one I got on deck is Martin versus Lessons of Waldale. Now have fun with this, y'all. I want y'all to have fun with this. Now this is from Chief Justice Taney. Everybody know who Chief Justice Taney was?
Mm-hmm.
Yeah.
Somebody tell me who Chief Justice Taney was. Not a member, anybody else other than a member. Come on, somebody. Chief Justice Taney.
He was the judge in charge of the Dred Scott case.
Well said, sister. That was Sister Jones?
Mm-hmm.
Yes.
Well said, well said, well said. So this is Chief Justice Taney in the time era of Dred Scott. Now, Dred Scott was a slave of the British monarchs who at that time were indentured servants. And they were given their freedom under the so-called 1865. But Chief Justice Taney told Dred Scott that, I don't care if you're free or not, the Constitution can protect you. That's what he said. Now, you just read Article 6 of the Constitution in regards to the United States, but not just the United States. The states are still subject to the treaties, contracts, and debts that were created prior to its creation. Right?
Mm-hmm.
Now, we know that the Constitution of the United States derived their authority from Parliament, because they derived their authority or their Constitution originally in 1776, July 2nd. And in that Constitution, it says in the nullification clause or the provision clause, which is called an escape clause. If you go all the way back to the bottom, it clearly states that it is the true intent of Congress that it must be a reconciliation with Great Britain. And is that if the latter, i.e. the colonies, come back under the protection of Great Britain, then that Constitution is null and void. I'm gonna say it again. Under July 2nd, 1776 Constitution, before they amended it, 1777, September 20th. Hold on, I gotta sneeze. You gotta forgive me. Could you give me some tissue? I apologize. Okay. Before they amended, nah, I ain't gonna do it. Give me a second, y'all. I apologize. Okay, sorry about that. So before they amended the July 2nd, 1776 Constitution, there was a provision in that clause, it's called the provision clause, that stated that the true intentions of this Congress is for the reconciliation of Great Britain. And once that reconciliation was done, then that Constitution will be null and void. Now, the reconciliation has been done by way of 16-1-28 of the New Jersey Revised Statute, which was adopted as the common law in New Jersey, as we just stated in Smith versus Alabama. And if you read that statute, it says that an act to incorporate trustees of religious society in regards to property being held by way of certificates of corporations and corporation place thereof. So all the property that belongs to the church are being held by corporation by way of their certificate of incorporation. And they're not the trustees for the true religious incorporation. Why? Because we have become extinct. Why? Because the fee is simple, common recovery. Now there's no more entail estate regard to the crown land because everything has been surrendered to the heads of states, whether they're under a commonwealth or whether they're under the head of state of a sovereign state. So this is why we must revisit the origin of the Constitution. And we know that the Constitution of July 2nd, 1777 was amended September 20th, July 2nd, 1776 was amended September 20th, 1777. Once again, the July 2nd, 1776 Constitution of New Jersey was amended September 20th, 1777, when they changed it from they changed it from colony to colony, from colony to colony, hold on, get them wrong. They changed it from colony or colonies to states and states. So when you change it from states from colony or colonies, that was a violation of the original agreement as we just read in Article 6. Because all debts, all contracts made before the adoption of this Constitution of the United States and the states are should remain in effect. There were treaties made, not just with the United States, but with the monarchs made prior to the creation of the United States. British monarchs, French monarchs, Spanish monarchs. These was a whole bunch of treaties made that we have to consider as a part of the equation in regards to fit our narrative. Well, here we hear Chief Justice Taney, which means, according to Article 12 of the July 2nd Constitution of 1776, Chief Justice from Supreme Court are all inferior officers.
Yep.
Every one of them. Supreme Court, District Court, Superior Court, Municipal Court, they are all inferior. Why? Because they have encompasses as established by the Constitution. But the Constitution don't check the citizen because the Constitution was put in check to protect rights, not give any rights.
Mm-hmm.
Now, what rights did the citizen have prior to they were calling states? They were supposed to be calling colonies, and we know the colonies didn't have any rights because they were naturalized citizens. They were citizens now living on plantations allowed by a grant given by a monarch who was not the English monarch, but the British monarch, where slavery existed, which you're going to read. All right, so let's get busy. We're going to call upon the new sister who came upon us, Sister Harris. You mind reading for us?
Sure. Start. Merritt, Martin, and others, plaintiffs in error versus the legacy of William C.H. Waddell, defendant in error. Supreme Court of United States. 369. The case was argued by Mr. Wall and Mr. Wood for the plaintiffs in error and by Mr. Ogden and Mr. Wright for the defendant. 406. Mr. Chief Justice Taney delivered the opinion of the court.
Now stop. Now remember, we think of Dred Scott and all his ancestors. Remember that. Dred Scott didn't know what we know as English people. This is the judge. This is your relief when you go to court in regards to a birthright. Not a live birth, but a right of birth or a birthright, same thing. Now, Dred Scott was a party in the matter in regards to birthright. But birthright under that, in that time and era, was based off just soil, just soil. You got two types of birthright. Just soil, meaning born of the soil, and just sanguineous, born of the blood. When just soil was adopted by the United States under the Calvin's case, which in regards to Calvin, who was the subject of King James. I think it was the case in 1608. King James claimed the throne of the English monarch in 1603. He was not the king of England. He claimed to be the king of England, but Parliament did not allow that. Mm-hmm. So he claimed the right of the English monarch, just like Henry VIII did, as styling himself the head of the Church of England. They all descended from the same church. the Church of England. One was a Roman Catholic and one was a Protestant. Same thing. All right, now, we have to ask ourselves in regards to getting a favorable reply, because it says you go on the intelligent tone and you get a favorable reply. Now, Chief Justice Taney is dealing with an argument brought before parties in the state of New Jersey, where we are incorporated in under our Articles of Incorporation, just like the Articles of Confederation was done by trustees who were called board members of an aggregate corporation called those who were assumed to be presidents of the United States. Nothing more than a company. Make sense, everybody?
Follow.
All right. Look at what Chief Justice Taney says. Go ahead and read. Sister, let me get the name right.
Yes.
Sister
Harris.
Harris. I apologize.
No problem.
Okay.
This case is brought here by writ of error from the Circuit Court of the United States for District of New Jersey. It was fully argued at the last term, but it was not then decided. 407. Because the
You
important
don't have to read the numbers. Don't read about the numbers.
Okay. Because the important principles involved in it made it proper that the case should be heard and determined by a full court. And as some of the justices were not present at the former hearing, a re-argument was ordered. In pursuance of this order, it has been again elaborately discussed by counsel, and having been carefully considered by the court, I'm instructed to deliver their opinion. The questions before us arise upon an action of ejectment instituted by the defendant in error, who was the plaintiff in the court below, to recover 100 acres of land covered with water situated in the township of Perth Amboy in the state of New Jersey.
Stop. Now, we are incorporated in Perth Amboy. That was the first seat of government in Perth Amboy. Benjamin Franklin, son William Franklin, told William Livingston that if you break away from Great Britain, you're going to be in trouble. And this is a case dealing with land ownership under fee and simple, not entail. Under common recovery, not entail. And look what Chief Justice Taney had to say about it. Continue on.
At the trial in the circuit court, the jury found a special verdict, setting forth among the other things that the land claimed lies beneath the navigable waters of Raton River and Bay, where the tide ebbs and flows, and it appears that the principal matter is in dispute, is the right to the oyster fishery in public rivers and bays of East New Jersey. The plaintiff makes title under the charters granted by Charles II to his brother, the Duke of York, in 1664 and 1674, for the purpose of enabling him to plant a colony on this continent. The last mentioned grant is precisely similar to the former in every respect and was made for the purpose of removing doubts which had then arisen as to the validity of the first. The boundaries in two charters are the same, and they embrace the territory which now forms the state of New Jersey. The part of this territory known as East New Jersey, afterwards by sundry deeds and conveyances, which is not necessarily to enumerate, was transferred to 24 persons who were called the proprietors of East New Jersey, who by the terms of the grants were invested, within portions of territory conveyed to them with all the rights of property and government which had been originally conferred on the Duke of York by the letters patent of the King. Some serious difficulties, however, took place in short time between these proprietors and the British authorities, and after some negotiations upon the subject, they in 1702 surrendered to the crown all the powers of government, retaining their rights of private property.
All right, stop right there, Ms. Harris. Now, what's very important is that this time era is talking about George Carteret and John Berkeley. George Carteret and John Berkeley, or I forgot, it's somewhere around there, George Carteret and John Berkeley. And this is when all the territory that was given to him by a grant by the monarchs was succeeded back to Queen Anne in 1702. And the flag before it was called New Jersey was the flag you see flying behind your king. This is the flag that was flying here in Perth Amboy, because it was the grant given by Charles II to his son James II. And James II gave a grant to the, I would say, profiteers, and they surrendered back to the crown in 1702. And in 1714, Queen Anne passed it to King George I, and so on and so on and so forth. All right. Archbishop, want to make any inquiries?
Well, like you said, everybody who came in underneath the British monarchs were all naturalized citizens. And as you know, as naturalized citizens, they're still a denizen, i.e. an alien. And if you do the etymology of the term alien, it means slave. So anybody who's coming in underneath the British monarchs, they were enslaving.
Well said. Start right here at the king.
The right of the king to make this grant with all its prerogatives and powers of government cannot at this day be questioned. But in order to enable us to determine the nature and extent of the interest which is conveyed to the Duke, it is proper to inquire into the charter of the right claim by the British Crown in the country discovered by subjects on this continent, and the principles upon which it was parceled out and granted.
One more, let me impose again. Now, we just read that it said that crown land is governed by the crown by way of corporation soul. And it's adopted the common law was adopted by crown land, whether they were called parishes, states, dependencies, overseas territories, public land, private land. It was all under the jurisdiction of the crown of the king. Now, at this time in question, we are sitting under the authority of British monarchs. British monarchs, not English monarchs, because King James VI of Scotland was a Scottish monarch, not an English monarch. Because if he was the first king of England, then why would you? That would mean that we're still in the Middle Ages. Am I right? We would be, and the time King James came to be the first king of England, we would still be in the Middle Ages at that particular time. And she assumed to be the role of the first king of England. He was not. He was a Scottish king given authority under the authority of the House of Tudors under Elizabeth I to what we call the Elizabeth religious settlement, because they're about to state it right now. Go ahead and finish reading, Sister Harris.
The English possession in America were not claimed by right of conquest, but by right of discovery. For according to the principles in the international law, as then understood by the civilized powers of Europe, the Indian tribes in the New World were regarded as mere temporary occupants of the soil, and the absolute rights of property and dominion were held to belong to the European nation by which any particular portion of the country was first discovered. Whatever forbearance may have been sometimes practiced towards the unfortunate aborigines, either from humanity or policy, yet the territory they occupied was disposed of by the government of Europe at their pleasure, as if it had been found without inhabitants. The grant of the Duke of York, therefore, was not of the lands won by the sword, nor were the government or laws he was authorized to establish intended for a conquered people.
You hear that? Did you hear that? They tell it on themselves. This is Chief Justice Taney telling you that it was the colonists who came over here and established the principles of what they call citizenship. But the English was already here, because English was here and you had colonization under a British monarch. And how could you say he was an English monarch? Because you had treaties made pursuant to that which you established over here. You had Spain, you had French, they were over here and they had contracts, they had arguments made with England, who was under these territories. All right, now let's get this before we go on with this case, let's just go here for a second. Another reference. Oh, the Chen Bao. Read right here. This is Wheeling versus Chen Bao, Supreme Court 1927. Now read what this says.
The very learned and useful of Mr. Justice Gray, speaking for the court in the United States versus Wong Kim Ark, established that at common law in England in the United States, the rule was with respect to nationality was that of the jus soli, that birth within the limits of the jurisdiction of the Crown of the United States as the successor of the Crown, fixed nationality, and that there could be no change in this rule of law except by statute, that by statute of 7 Ann, extended by the statute of 4 George II, the second, 1731, C21, all children born out of the allegiance of the Crown of England, whose fathers were or should be natural born subjects of the Crown of England or of Great Britain, at the time of the birth of such children, respectively, were deemed natural born subjects of that kingdom to all intent and purposes whatsoever. That statute
I need you to read that again. Stop right there. I need you to read that whole thing again and read it slow for everybody.
Okay. The very learned and useful opinion of Mr. Justice Gray, speaking for the court in the United States versus Wong Kim Ark, 169 U.S. 649.
Don't read about this. Don't read all the numbers and all that.
Okay.
They can read it for themselves.
Okay. Establishes that at common law in England and the United States, the rule with respect to nationality with that of the jus soli, that birth within the limits of the jurisdiction of the Crown of the United States as the successor of the Crown, fixed nationality, and that there could be no change in this rule of law except by statute, that by the statute of 7 Ann, extended by the statute of 4 George II, all children born out of allegiance of the Crown of England, whose fathers were or should be natural born subjects of the Crown of England or Great Britain, at the time of birth of such children respectively, were deemed natural born subjects of that kingdom to all intents and purposes whatsoever. That statute was
That's
extended.
cool. Right there. Stop right there. Now, look at what this judge is saying. First, they're talking about just soil. And we know there's a difference between just soil and just sanguineous. We know just soil is just being born on the soil. And just because you're born somewhere, don't make you a citizen. Am I right?
Correct.
Yes.
Everybody know that, right? Just because you're born here, do not make you a citizen.
Right.
At all.
Right.
So now you hear a case between two parties, United States versus Wong Kim Ark. Now, one is I guess Chinese national, and one is assumed to be a United States citizen, but it can't be a national. Because the United States at one time was a colony of foreigners. So if you are talking about national, then that's why they say just soil, because just soil, you're just being born here, but you can't throw your allegiance off from where your mother country come from, which in this case would be a foreign national.
Exactly.
You would be a foreign national, not a national, because it just said here under Judge Gray, it said it's established that the common law of England and United States. It didn't say British, it didn't say Scottish, it didn't say Dutch, it didn't say none of those nationalities but England. Here in the United States, not only the United States, but the states. That makes sense to everybody?
Yeah.
Yes.
And it said that the United States is the successor of the crown. Now, how you got the United Kingdom claiming to be the crown when it just said on the Supreme Court that the United States is the crown, and the crown governs the crown land, whether it's public lands, whether it's private lands, whether it's overseas territories, whether it's dependents. That means that all the Commonwealth, all the sovereign states that's being overseen by these heads of states are really subject to the crown. Why? Because the crown is the executive, legislative, and judicial authority. And that can only be granted by the government, i.e. Parliament. And if you understand legislative law, the United States borrowed the laws, or what we call the common law, which was established by what we call the Westminster system, or what we call the parliamentary government. And the first model of parliamentary government was established by Edward I. Edward I is the son of Isabella of Provence and Henry III. Henry III is the son of John. John is the son of Henry II and Eleanor Aquitaine, who was a Roman Catholic, which broke the Act of Succession, which is the reason why we're here today. So as is established, based off United States versus Juan Kim Ark, that the crown was inherited by successors, which is the United States. But did it say heir?
Sure didn't.
It just said successor.
The successor.
If it was an heir, it would be entail, because it said crown land is an entail estate. If it just says successor, then that's being simple, because the successor is somebody who's assumed to be a beneficiary of a trust left from somebody other than the original grantor. See, ain't no king in the position. So all those persons who are assumed to be the grantor are doing it by way of fee and common recovery, which is fee and simple. And fee and simple is by way of having a legal fiction man or a go-to man called a straw man or a corporation. And the corporation is done as the go-to guy. So when you claim an interest in a mortgage, it's called a dead pledge.
Yep.
It's called statute of mortmain, a dead pledge. So I don't care how much money you put into it, you're never gonna own it because it's taxes paid to the crown. Because it just said the crown owns everything. United States, the states and the colonies owe a debt to the crown. Because under 46, let me see, I got it right here. Common law, y'all.
Now remember,
okay.
the several.
Go ahead, Archbishop.
I said, remember, the several states themselves at the time were considered sovereign, but they gave that sovereign power to who? To the federal government, which means they relinquished their so-called power that they received from the so-called crown. And as you see now, the United States is successor.
Okay, all right. Now most of us say, well, a corporation soul, which we already know is a natural person and an entity at one time, acting in one capacity, which often never dies. And the obligation of the corporation soul is to make sure that the property of the church stays intact as part of the religious society, to make sure that it doesn't fall into the hands of what we call a visor of Christ. An advisor of Christ is a Roman Catholic overseer called either an apostolic prefect or the apostolic vicariate. That's over in the Commonwealth. In the United States, they're called ministers, plenipotentiaries, or ambassadors. An ambassador's job is to set up an embassy in a foreign territory to protect its foreign nationals. Now, we just read in the court case that the only way birthright can be considered here in the United States is based off just soil, and that's what they call nationality. But we know that if it's based off just soil, you just being born here based off in a little bit of nationality, then we know that if it's going back to Calvin case under Minarch, then that's not a true national. That's a foreign national. That's why you have a British embassy over here in North America. It's called the UK embassy. You have an embassy for French nationals. You have an embassy for Moroccan nationals. So if Moroccan claimed to be a Moorish American, and you have an embassy in America, matter of fact, in New York, to protect Moroccan nationals, then why are you not seeking protection as a foreign national if you're foreign to the United States? But you can't be foreign to the United States because your allegiance is to America, because you call yourself Moorish American. And America is the United States. United States are those who came in on a contract, but they were not the original parties. Why? Because the United States created their Constitution in 1789. When they became residents in 1780 and 1790 by the Residence Act. And these same residents were the descendants of those residents who were colonists living on plantations by way of the Plantation or Naturalization Act of 1740. All that originated from the Settlement Act of 1701. And the Settlement Act was an act created by Elizabeth I, who was the daughter of Henry VIII through the English Reformation, when all the churches, all the parishes, which are now called municipalities, boroughs, counties, township, etc., were now ran by parishes under the authority of now what we call the Roman Catholic Church, because the Roman Catholic Church are now back in bed with the Protestant Church by way of the Treaty of Paris of 1783 through what we call the Apostolic Prefect by the name of what we call John Carroll. Now, King James then broke away from the Roman Catholic Church by way of what we call the English Reformation in the 15th century. So now why do we have all these dioceses in every parish of every municipality, of every county, of every state in the United States, within the 50 states of the United States of America? Why? Because we're still under occupation. Now read what this said. Now we just said a corporation's soul is the executive, legislative power. And you are all members of the corporation's soul, but you are the aggregate members, just like a corporation. A corporation is not a corporation soul because it's made up of many members who all come together to fulfill one purpose, the mission of the so-called corporation. So we don't call ourselves a church. We call ourselves a mission as missionaries to revive ourselves from foreign missions who have occupied ourselves to establish what we call embassies for foreign nationals. Because if we're nationals, then we don't need no embassy us because we are nationals here. So if anything needs to be established here for the nationals, is an embassy to protect us from foreign nationals doing business on our land. Because the only way you exist here is by way of trade and commerce, which has to stop. Why? Because that's called capitalism. Capitalism is called feudalism. Feudalism has been abolished. How we know that? Read what this says. Brother Munde from the House of Munde. We can't hear you, Noble.
2021 New Jersey Revised Statutes, Title 46 Property, Section 46(3)(2), certain tenors or holdings turned into free and common
soakage.
Soakage.
Yeah.
Yeah.
Just read this right here. Right there. All the way down.
46 certain tentures and holdings turned into free and common soakage. The tentures of honor, manors, lands, tenements, or
hereditaments,
or of estates of inheritance at the common law held either of the King of England or of any other person or body, politic, or corporation, or corporate, at any time before July 4th, 1766. I got some on my screen. Hold on.
Don't worry about it.
76, excuse me, and 76, and declared by Section 3 of an act entitled Act Concerning Tenors, passed February 18th, 1795, to be turned into holdings by free and common soakage from time of their creation and forever thereafter, shall continue to be held in free and common soakage, discharge of all the tenors, charges, and incidents
enumerated
in Section 3.
Okay, now let's break this down. For one, this is a 2021 statute. For one, it's a 2021 statute. It's a certain tenures, which can be an office or holdings, turn into free and common soakage. Free and common soakage is a sort of tax that was paid to the King of England. Now you in 2022. It's the tenures of honors, manors. Manors can be something, a big estate sitting on the hill. Lands, tenements. Tenements can be something like an apartment building, complex, or hereditaments. and that's property. Hereditament denotes the property. So anything dealing with assets, i.e. property, involving everything we just said in the former, which is called an estate, which is left by way of inheritance at the common law, held either by the King of England. It didn't say the King of Scotland. It didn't say the King of Ireland. It didn't say any king of anywhere other than the King of England or any other person. That means that any other person sitting in that office as the King of England. That's what that means. Or body of politics or corporate at any time. So that means that if somebody in this day and time, under 46:3, 46:3 test, or 16:1 16:1-43.7, 8, and 9, constitute corporation. So what this means is that a corporation, or a religious corporation, because everything is a corporation. That religious corporation which our ancestors created is called a cestus quae, trust for heirs. When that trust was created, it had to be activated by way of somebody sitting in the pilot seat. Somebody had to be sitting in that pilot seat in order to drive the ship. So it said the King of England or a person and body of politics. That's a tenure. A tenure is a holding or office that you hold, just like every office hold, whether you're dealing from a commonwealth or a sovereign state. They're all holding offices, sitting in the tenure, and they're persons, i.e. corporation, because a person can be a corporation as established doing diversity of jurisdiction, as established based off the background. And it said at any time before July 4th, 1776, that's the day that the United States declared their independence from Great Britain. They established the Constitution on July 2nd, 1776, but then declared their independence July 4th, 1776. All right, so I let you know that all those contracts that were made on any manor land tenement pursuant to hereditatements called in the state based off of hereditatements that were made prior and before are null and void now, and now remain under free and common succus, which means that everything that was held by the king on the Lodio is now being held by the Lodio and free and common succus. How we know that? Let's go here. Go ahead. I'm just going to show you guys just one more statute before we go forward with the case law. Read just Brother Monday.
New Jersey Revised Statute, Title 46, Property, Section 46, 3-6, Gifts, Grants, and Conveyance by State Allodial. Gifts, grants, and conveyance by State Allodial. All gifts, grants, or conveyances made prior and before July 4th, 76 of any estate of inheritance by letters patent under the Great Seal of this state or in any other manner by this state, by the legislature thereof, or by the commissioners or agents of forfeited estates, or by other lawful and competent authority under this state shall be and remain allodial and not feudal, and shall forever be and continue in free and pure allodial only, forever discharged of all feudal tentures and the incidents thereof, and all other services whatsoever.
Okay, so that's letting you know that the land is allodial. Ain't no more feudal tenure. So if you're making money off this land, then you got a problem. Because you ain't supposed to be making money for yourself. All this is supposed to be going back to the king, because king is the owner of the allodial land, because the allodial land is under the crown land, under authority of the crown. Does that make sense to everybody? Let's go ahead, and I'm gonna prove it by this one. Because we already know what fee and simple means. Common recovery. Read this, Brother Mundi.
Fines and common recoveries abolished. 4346 3-10. From and after June 12th, 1799, no fine or common recovery that has been or shall be entered, made, had, or suffered in any court of record of this state shall operate or be construed to be a conveyance of assurance of real estate, or in any way bar the issue entail of the revisioner
or remandament.
Reversioner or remandament of their lawful claims and entries, any usage of custom to the contrary, in any wise notwithstanding.
Ooh, that's heavy. That's heavy. First of all, let's go back to common recovery and see what that is. Common recovery was a legal proceeding in England that enabled lawyers to convert an entail estate, i.e. crown land, a form of land ownership also called fee entail, into absolute ownership fee and simple, which is legal fiction. This was accomplished through the use of series of collusive legal procedures, some parts of which were fictional and others unenforceable and therefore null. So if you just read under the revised statute, that practice was abolished then, it's abolished now. It's abolished now. Why? Because the land is a lodio. And in order for it to be a lodio, there must be a king. It said it. Chief Justice Taney just said it. Let's go back to Taney. Oh, not Taney, which was that case? I think it was Chimbo. It's that the very learned and useful opinion of Mr. Justice Gray, speaking for the court in the United States versus Wong Kim, are two foreign nationals. Everybody trying to make a claim on land here on English soil as foreign nationals. And look what the courts are saying, Supreme Courts. Why? Because they're obligated to obey that Constitution, which was adopted by the colonists to protect their form of government. But it didn't in any way encompass us to those encumbrances. Why? Because they were living off our virtues because we didn't know who we were. Once we woke up, the true intent of that Constitution was the reconciliation with Great Britain and protection of the heirs of Great Britain and all the lands that were transferred to Great Britain by all the treaties. The Treaty of 1783 of Paris, Land Ordinance of 1787, to Thomas Jefferson, everything east and west of what we call the Appalachian Mountains, as well as the Treaty of Alliance, all commerce done on this land. The Treaty of Paris of 1763, when Spain and France ceded everything to Great Britain. Then you got to go to all the treaties of Albertville, 1259. All that story goes back to that family crest or family flag you see flying behind the King's Bench. All right, and if you look at this statute, these are monarchs confirming that the authority and successor of the crown is the successor of the United States. That was done by Queen Anne, King George II, as well as King George III, as well as confirmed by the 4th, the 5th, the 6th, the 7th, as well as confirmed by Elizabeth II, because Elizabeth II is not the head of the government. She's only the head of state, and the head of state is nothing more than what we said, a figurehead. Let's see what this said. Let's go ahead and state first. All right, you can read, brother. Let's see who else we got here. I know somebody else I want to get. Brother
Walthor.
Brother Walthor. No, I'll just give the new brother a chance. Where is he at? What you hiding from me? What's that?
Oh, brother, the other brother that was on, no, he's not on anymore. Watson.
Okay, yes, okay. All right, sister, brother Walthor, you can read. Head of state.
A head of state or chief of state is the public persona who officially embodies the state in its unity and legitimacy. Depending on the country's form of government and separation of powers, the head of state may be a ceremonial figurehead, such as the British monarch, or concurrently the head of government, and much more, such as the President of the United States, who is also Commander-in-Chief of the U.S. Armed Forces.
Read that again. Read that again.
A head of state or chief of state is the public persona who officially embodies a state in its unity and legitimacy. Depending on the country's form of government and separation of powers, the head of state may be a ceremonial figurehead, such as the British monarch, or concurrently the head of government, and more, such as the President of the United States, who is also Commander-in-Chief of the U.S. Armed Forces.
Stop right there. That's all we got to go. Head of state is a persona who officially embodies a state and its unity and legitimacy. Depending on the country's form of government and separation of powers, the head of state may be a ceremonial figurehead, such as the British monarch. Specifically, they mentioned a British monarch and a president, both of them. So none of them two can wiggle out of this term figurehead. So now what's the figurehead? Second. Read what that says, Brother Walter.
In politics, a figurehead is a person who, de jure, in name or by law, appears to hold an important, often supremely powerful title or office, yet de facto, in reality, exercises little to no actual power. This usually means that they are head of state, but not head of government. The metaphor derives from the carved figurehead at the prow of sailing ships.
Stop right there. This is why it's important to determine what's admiralty and maritime law. Because if the word figurehead is a de facto term for a head of a ship, and we know ships do business on what? Water.
Water, yep.
Right? The crown is the land. So they can't do business on the crown because the crown is the land, crown land. So if they do any business under the figurehead or the persona of the so-called as the head of state, it's only dealing with commerce, admiralty, and maritime law. So if you are a citizen of these heads of states, as pursued to be de jure, but de facto in nature as established by the title figurehead, which is only for ceremonial purposes. So therefore, you're subject to the laws. Make sense? Okay, let's go back here. Where we at? All right, go back to this case law. Let's go. You can ready to start from here.
Check, give me 1 second. The country mentioned in the letter's patent was held by the king in his public and regal character as a representative of the nation and in trust for them. The discoveries made by persons acting under the authority of government were for the benefit of the nation and the crown, according to the principles of the British Constitution, was the proper organ to dispose of the public domains. And upon these principles rest the various chapters, charters, and grants of territory made on this continent. The doctrine upon this subject is clearly stated in the case of Johnson versus McIntosh. In that case, the court, after stating it to be a principle of universal law, that an uninhabited country, if discovered by a number of individuals who owe no allegiance to any government, becomes the property of the discoverers, proceed to say that if the discovery be made and possession taken under the authority of an existing government, which is acknowledged by the immigrants, it is supposed to be equally well settled that the discovery is made for the benefit of the whole nation, and the vacant soil is to be disposed of by that organ of the government, which has the constitutional power to dispose of the national dominions by that organ in which all territory is vested by law. According to the theory of the British Constitution, all vacant lands are vested in the crown as representing the nation.
Stop.
And
Now, didn't it say the United States was successor to the crown?
yeah,
And now he's saying that the British Constitution, all vacant lands belong to the crown. So even the British monarchs are telling you that all this land belongs to the crown. Why? Because it was England that the crown was originated, and it was brought over here by the British colonization. Why? Because over there, what they call England was nothing more than an overseas possession.
Exactly.
So you're standing in England.
Mhm.
All right, keep reading.
an exclusive power to grant them is admitted to reside in the crown as a branch of the royal prerogative. It has been already shown that this principle was as fully recognized in America as in the island of Great Britain. This being the principle upon which the charter in question was founded, by what rules ought it to be construed? We do not propose to meddle with the point which was very much discussed at the bar as to the power of the king since Magna Carta to grant to a subject a portion of the soil covered by the navigable waters of the kingdom, so as to give him an immediate and exclusive right of fishery, either for shellfish or floating fish within the limits of his grant. The question is not free from doubt, and the authorities referred to in the English books cannot perhaps be altogether reconciled, but from the opinions expressed by the justices of the Court of King's Bench, in the case of Blundell versus Cotterell, and in the case of the Duke of Somerset versus Fogwell. The question must be regarded as settled in England against the right of the king since Magna Carta to make such a grant. The point does not, however, arise in this case unless it shall first be decided that in the grant of the Duke of York, the king intended to sever the bottoms of the navigable waters from the prerogative powers of government conferred by the same charter, and to convert them into mere franchises in the hands of a subject to be held and used as his private property.
Stop. Now, what they're talking about is the Virginia Charter of 1606, because the Virginia Charter covers everything from North Carolina all the way up to Maine. These are called the territories of the 13 colonies. So this case is in regards to those proprietors claiming to own the property, but no one had the right to own the property in lieu of the original charter, because the charter is a contract. It's not a government. It's a contract. And a contract can also be a grant, an agreement granted by the monarch. And they're going back to the Magna Carta, and the Magna Carta says that the English church should be free. So when everybody deals with their rights under religious freedom, they take it in the spirit of the Magna Carta. But the Magna Carta was only preserved by the government that established it, which is Parliament. And Parliament law supersede Constitution, statutes, grants, etc., and which is the case being heard here, that when the judge revealed on their standard of review in regards to their memorandums, it had to be based off the common law of England and the origin of where it stemmed from in light of that history. Go ahead.
And we the more willingly forbear to express an opinion on this subject, because it has ceased to be a matter of much interest in the United States.
You hear that? Do you hear that? The United States don't care about this history. It's not their job to reteach you this history. It's your job to remember it, because they're the trustees over it. If they're sitting over your trustees and they're able to call the shots, they can tell you when to get your money, when you can't get your money, if you're competent enough. Why? Because you are considered incompetent, non-commos mentes. You're not able to deal with your affairs. You're a ward of the state. That's the period because you're a state citizen. Why? Because everything that the state do is held in trust. Continue on.
For when the revolution took place, the people of each state became themselves sovereign. And in that character, hold the absolute right to all their navigable waters and the soils under them for their own common use, subject only to the rights since surrendered by the Constitution to the general government.
Stop. That's how they tricked us. They try to tell us that, hey, if y'all get along with us, y'all gonna have your own rights, free and sovereign. What it said, the government was instituted for the protection of the people, right? He said the power is in the people. The government was instituted for the protection of the people. It didn't say the people instituted the government. It said the government instituted the protection for the people. But what people are we talking about? Why would you give up your sovereignty to something that was born by birthright?
Right.
It's already in place for you.
Because it wasn't
You're
there.
born into that protection.
Right.
Now when you're born, you got to hope they want to give it to you. It's their choice to give it to you or not. Then that's not your government. That's position Dred Scott found himself in. When you read the decision of Chief Justice Cheney with Dred Scott and the decision with the decision in regards to the English wife, there was a totally different point to reveal. Now, if you read Dred Scott case, Chief Justice, I think his name was Curtis, said that in spite of what Chief Justice Cheney said, he said, well, in England, I don't care what complexion you were, people in England were free. He said it was not to the British colonization that the English people became subjects, and he said that that's when English slavery, that's when slavery began in the British colony. So that lets you know when British allowed immigrants to come here from foreign nations, they themselves became subject and at the will of their master, i.e. being subjects, when at that time were practicing slavery. Make sense?
Wow.
Continue to read.
A grant made.
Sorry about that.
A grant made by their authority must therefore manifestly be tried and determined by different principles from those which apply to grants of the British Crown, when the title is held by a single individual in trust for the whole nation.
All right. So a corporation sold, the king is the trust, as it's stated in this case law. And not in the case law, in this case law, Chief Justice Cheney. He said the king is responsible for the trust. And we know a trust is handled by what? A trustee. A trustee is the administrator of the trust. But what trust are you beneficiary of? You ain't beneficiary to the trust that was created by the state, because the state don't have your interest in their best interest. Why? Because to you, you are property. You are the trust. Continue to read.
Neither is it necessary to examine the many cases which have been cited in the argument on both sides to show the degree of strictness with which grants of the king are to be construed. The decisions and authorities referred to apply more properly to a grant of some prerogative right to an individual to be held by him as a franchise, and which is intended to become private property in his hands. The dominion in property is navigable waters, and in the land
I'm sorry.
Lands under them, being held by the king as a public trust.
Y'all hear that? Read that again. I just said that.
Yeah.
I just said that. Held by the king as a public trust. Go ahead.
The grant to an individual of an exclusive fishery in any portion of it is so much taken from the common fund entrusted to his care for the common benefit. In such cases, whatever does not pass by the grant still remains in the crown for the benefit and advantage of the whole community. Grants of that description are therefore construed strictly, and it will not be presumed that he intended to part from any portion of the public domain unless clear and special words are used to denote it. But in the case before us, the rivers, bays, and arms of the sea and all the prerogative rights within the limits of the charter undoubtedly passed to the Duke of York and were intended to pass, except those saved in the letters patent. The words used evidently show this intention, and there is no room, therefore, for the application of the rule above mentioned. The questions upon this charter are very different ones. They are whether the dominion and propriety of the navigable waters and in the soils under them pass as a part of the prerogative rights annexed to the political powers conferred on the Duke, whether in his hands they were intended to be a trust for the common use of the new community about to be established.
Read that again. What are they talking about? A new community about to be established?
Yeah.
Don't
right.
that sound like New Jerusalem, the new city of peace? Yeah. It ain't yet got here. Why? Because it wasn't for them. They was there just to administer the trust until we came of age, i.e. the age of majority, i.e. where we're not non-como mentors, so they can stop administering the trust, that we can look over after our own estate as required by 16:1-28, a right to incorporate trustee, because the trustees deal with the trust.
Yeah.
Continue to read.
You want me to start over? Or you want me to continue?
No, continue.
Okay. And in deciding a question like this, we must not look merely to the strict technical meaning of the words of the letters patent, the laws and institutions of England, the history of the times, the object of the charter, the contemporaneous construction given to it, and the usages under it for the century and more which has since elapsed, all entitled to consideration and weight. It is not a deed conveying private property to be interpreted by the rules applicable to cases of that description. It was an instrument upon which was to be founded the institutions of a great political community, and in that light, it should be regarded and construed.
Oh boy. One second.
And right after this, we're going to take a break, King.
Okay, Noble. This is the last one.
Taking this rule for our guide, we can entertain no doubt as to the true construction of these letters patent. The object in view appears upon the face of them. They were made for the purpose of enabling the Duke of York to establish a colony upon the newly discovered continent, to be governed as nearly as circumstances would permit, according to the laws and usages of England, and in which the Duke, his heirs and assigns, were to stand in the place of the king and administer the government according to the principles of the British Constitution. And the people who were to plant this colony and to form the political body over which he was to rule were subjects of Great Britain, accustomed to be governed according to its usages and laws.
Wow, we stop right there. We're gonna start right there. We're gonna come back to that. So you're seeing the truth being revealed in regards to the true heirs and successors as admitted by the establishment of the British kings, who now created their own constitutional government by way of allowing colonists to come here, known as proprietaries, and establish principles to govern themselves in lieu of them doing business here in regards to protecting the estate of those who died and became extinct as a result of our ancestors who died in ignorance as a result of non-como mentors. So with that, we're in with part one, and we'll see you shortly part two. And everybody, get their water, take your bathroom break. We'll see you back here shortly. And with that, I digress.